I apologize.
We are inquiring about what we're considering so that we can have that in mind as we
Only me and me alone will know that. I have constantly told both sides from the outset when I first took over this case. I personally gave each one of you the Ninth Judicial Circuit Courtroom Decorum Policy, which is enacted by administrative order and has been in place. If I can remember, I signed this order in February of 2003. I gave everybody a copy. More specifically, item 12. Counsel shall admonish all persons at counsel tables that gestures, facial expressions, audible comments, or the like as manifestations of approval or disapproval during the testimony of any witness or at any other time are absolutely prohibited. There has been this accusation throughout the trial that has been going on back and forth. I have told you on numerous occasions I spend very little time watching the attorneys. I assume that you are all professionals, that I don't have to watch. You're all charged with the responsibility of following the law. So maybe I am misinformed when I think you will follow the law. But I'm beginning to see that orders or anything else may not mean a hill of a bean to any of you. So go look at it, and I'm going to do what I need to do.
I trust your judgment about whatever it is you saw, and I don't need to see it.
Mr. Mason, your side still wants to see it. Ms. Burdick, you want to see it?
I do, Your Honor.
Okay.
I trust your judgment has to do with it.
I'm sorry, I can't hear counsel.
I do want to see it. It has nothing to do with posting the judgment. It has to do with taking the advantage. I got what's going on.
Well, they'll let you know as soon as it's available.
It is the case in Judge Belvin Perry's courtroom that no one make facial expressions. Holly Brister will tell you that even if you think you're holding an ace-high flush, you better not let the other person across the table know it. And Jeff Ashton is accused of doing just that. Guys, tell me again, why is Cheney Mason insisting on seeing this?
Well, I think he's sticking up for Jose Baez, and I think he's going to make the point that Jose Baez had brought it to the court's attention, and it kept happening. And the fact that he pointed it out in front of the jury, whether he was complaining to the judge or just pointing it out to the jury, doesn't make him as bad as the original offender.
Yeah, he's going to try to make the point that this was an invited violation, where Ashton's conduct invited Baez to violate as well. It's not going to work. I predicted we're going to have a contempt proceeding coming up, and let me tell you how important that is. This is going to be direct criminal contempt. And unless the judge withholds adjudication on that, we're fixing to watch two lawyers be convicted of a crime.
Why? Why is it criminal contempt, Brad?
Because it's occurring in the courtroom directly in front of the judge.
Yeah. And in direct violation of an order. This is not something you can cure in terms of civil contempt. Criminal contempt, I told you not to do it, you did it anyhow, that's criminal.
And it's even more to the point because, yes, it can influence the jury and it shows some bias for the jury.
Absolutely.
It can affect the jury.
Yeah, no, I mean, that's why the rule is in place, absolutely, and that's why the violation is being taken so seriously. That's absolutely right. It's not, I mean, there's a rule against gum chewing, too, but you're not going to have anybody thrown in jail over it. This is, you don't want the jury to think, Jeff Ashton thinks that argument is laughable. You don't want the jury thinking that. It's not supposed to be about what the lawyers think about the evidence.
Let me tell you how serious this is. I believe that Jeff Ashton is a board-certified criminal trial attorney. And the Florida bar, in all likelihood, if he's found guilty of criminal contempt during a trial, will strip him of that certification.
Yeah.
It may not sound fair, but that's the way it works.
I think the judge has made his point. I think they probably should take this up, the remainder of it, after the trial. There's no need to have it affect either side's finish of their presentation, and getting this jury, this case to deliberate really is the number one priority. I hope we don't take up too much more time, frightening the lawyers involved.
I agree with you, Diana, but you know what? It goes beyond just this one instance. It really does undermine the integrity of the system in general.
Shannon, go ahead.
Did you see when Judge Perry walked out of the courtroom when we had that video of how everybody was coming out?
Yeah.
He was, talking to his deputies, and you could tell he was absolutely over the top at this point.
Yeah, he's
usually pretty good. When he comes out of court, he comes down the stairs, and he's walking. He's very, I wouldn't say jovial, but he's like, hi, how's everybody doing?
Yeah.
And it was none of that this time. He was fuming.
Yeah, he was as angry as when it first happened. We've got it. Let's take a look at it.
We're not talking about fantasy forensics anymore. We're talking about cold, hard evidence. Evidence that points to one person, and one person only. And he can get up here and lie all he wants and dance around the truth, but the truth is the truth. And depending on who's asking the questions, whether it's this laughing guy right here or whether it's myself.
Objection. Approach the bench.
Yeah, that was ugly. But it was obvious. He was laughing.
He was laughing.
He was absolutely laughing.
I'm sorry. I'm taking Jose Baez's. He told the judge this was a problem. It continues to be a problem.
Mm-hmm.
He was making the point. It depends who asked the questions. I think it was fair game. And to be honest, we keep talking about this is the end of the world, the laughing, the comment about the laughing. This trial has been very clamped down. Your normal murder trial would be a little bit lively. This kind of exchange would happen, and we would not be talking contempt and like this was this is in the big scheme of things. This is not that big a deal, but in this courtroom, in this trial with this judge, this is clearly was going to get both of them in trouble.
And
I think that's a bias.
The judge said that these rules have been in place since 2003, but I got it right here in front of me in black and white. Number 5, ridiculing the defendant's theory of defense won't be tolerated. Isn't that what he was doing right there? That was ridicule.
That was ridicule.
Yeah.